Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment, it was forged by law within a unique justice system born from the union of the civil law and common law and increasingly indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments.
Your home is your castle, but when can the government force its way in? Joining us is Professor François Tanguay-Renaud, an associate professor at Osgoode Hall Law School and the director of the Jack and May Nathanson Center on Transnational Human Rights, Crime, and Security. We discussed a landmark decision from 1984, Hunter versus Southam, a case that shaped privacy protections in Canada. On April 13, 1982, government investigators probing into potential unfair trade practices entered the offices of the Edmonton Journal to search their files. They arrived armed with an authorization from a government board member, not a judge. The newspapers challenged the search. The Supreme Court had to find a balance between state interest and individual privacy. This decision established the golden rule. You usually need a warrant before you search. But why was this specific search unconstitutional? I am Laurence Thériault, and you'll find out in this episode. Enjoy!
Professor Tanguay-Renaud, thank you for being with us. Thank you for sharing a little bit of your insight with us in Shaping Canada, 150 Years of Landmark Decisions. Welcome.
Well, the pleasure is all mine, Hugo.
I think our listeners are going to be very interested in the subject at hand. And let me read Section 8 of the Canadian Charter. Everyone has the right to be secure against unreasonable search and seizure. What does it mean in practice? What is a search? What is a seizure? What is the scope of that protection?
Well, so the decision that we're going to talk about today is really the seminal decision that set the stage for defining what search and seizures are. But in order to understand how we got to where we got, I think it's important to have a bit of a sense of how things were before the Charter. So historically, at common law, way back in England, the law contemplated very strong protections for people's property. Essentially people's houses. So in early English jurisprudence, you often encounter the expression, a man's home is his castle. If somebody were to intrude into your home, the common law would say, well, that's a trespass, right? You're not allowed to do this unless you're authorized by law. And the same with respect to a person's body. You're entitled to have your body protected. And if somebody's going to intrude upon your body, touch you without your consent, well, they need to have some legal justification. The term search and seizure were perhaps used colloquially, but they were not as central as they've now become in the era of the Charter, where we have this protection that you just read to us, Hugo, that everyone has the right to be secure against unreasonable search and seizures. But the thought was, irrespective of whether it's the king or, you and I, right? The thought was, if you're going to intrude upon these protected interests, you need some kind of legal justification, right? So that was the thought. And so that gave rise, if you want, there's an old case called Entick v. Carrington, a 1765 case that is often cited as the inception of all the thinking that we now have around search and seizure. I'll add to this that the Fourth Amendment of the U.S. Bill of Rights, right, which is the equivalent of the Canadian Charter in the U.S., goes as follows. It says it guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure. The kind of legal thinking that I spoke to you about in relation to the English case of Entick v. Carrington is actually reflected in the Fourth Amendment. So really a protection for property and protection for, the body. The charter actually introduced into Canadian law an actual legal remedy for things like, illegal searches and seizure. So part of the charter, if the police, performed an illegal search, entered your house without legal permission, sort of intruded upon your body without legal permission, you basically had two options. If the action of the state agent was under a warrant, but you would have to bring the legal action prior to any charges being laid. One problem is that this is rather limited in scope because search warrants were subject to a presumption of validity. So, for example, the wrong person had issued the search warrant. It didn't result in either the return of the item seized or in the exclusion of evidence. As it wasn't really likely to be successful or very useful prior to the charter, it isn't really more likely to succeed today. So today, writs of certiorari are only really rarely used to challenge warrants. They were invoked more prior to the charter because it was one of the only avenues to challenge a search. But again, without much chance of success. Now, the other possible response to an illegal search and seizure prior to the charter was that you could sue the police. You could sue the state, which again can still be done, right? So under the common law, an illegal search, well, as I said earlier, may be a tort of trespass or a tort of battery. So you can sue the police officer in tort. This also was and is still not super effective, not available or cost effective for most people. In England, there was a very limited judicial power to exclude evidence at common law. But this was actually a very narrow exception, and pre-charter, it was not available at all in Canada. Mm-hmm. In Canada, this judicial power is a new legal remedy that was created by Section 24, subsection 2 of the Charter. This section is not the one about which we're talking today, but what you need to know is that this is primarily the remedy that we have in mind for the rights that we're going to be discussing today.
Section 24.2 is the exclusion of evidence. It says where in proceedings under Section 1, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by this charter, the evidence shall be excluded if it is established that, having a regard to all circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. Love this word. These are common words, and I believe they have a common interpretation. Searching into your stuff and seizing, taking your things or taking a person.
If you read Section 8, you say, well, what does Section 8 protect? And what protects us against unreasonable search and seizure? It protects us against the state looking for, information about us and taking or gathering information about us in ways that are unreasonable. But that's actually not how the section has been interpreted. The section has been interpreted in a more restrictive way.
We're talking about the government doing something, and the government extends all the way to any civil servant, police, investigator of a ministry, of a branch of government.
Yes, the Charter is a constitutional document. Section 32 of the Charter defines the applicability of that document, and it extends to federal and, provincial governments, as well as to, whatever is done, on behalf of the government. So we're really talking about the government, but this is not just a point about Section 8, it's a point about the Charter as a whole. Charter was adopted in 1982. There were other constitutional Bill of Rights around the world that served as inspiration for our charter, and notably the U.S. Bill of Rights. So in order to understand the case that we're going to talk about today, I think it's important to understand the seminal case that was decided in the U.S. that plays the same role as the case that we're going to talk about today, because it's the main inspiration for that decision. The case I'm referring to is the case of Katz, K-A-T-Z v. United States. It's a 1967 decision of the Supreme Court of the United States. This judgment is actually referred to over and over again in the Canadian Section 8 jurisprudence. So I think it's a good place to begin, our consideration of search and seizure law. So what happened in that case? Mr. Katz, places illegal bets from a phone booth. The FBI decides to tap the said phone booth. And Katz moves to exclude the evidence that was thus, gathered, as a violation of his Fourth Amendment rights. So the U.S. Supreme Court in Katz says that the Fourth Amendment needs to be interpreted as protecting, quote unquote, people, not places, in the sense to protect people's reasonable expectations of privacy. Now, prior to Katz, the Supreme Court of the United States had understood the Fourth Amendment in terms, namely as protecting persons, houses, papers, and effects, just like the common law. And there's actually a dissent in the case by Justice Black, which basically lays out the status quo position. So where is Katz? He's not in his house. What's being searched? Not his person, not his papers, not his effects. So quite simply, he's not protected by the Fourth Amendment. So the innovation in Katz is that you have a majority of the U.S. Supreme Court say that the Fourth Amendment protects people, not places. So it says, in effect, that sort of the fundamental principle underlying the Fourth Amendment is the protection of some sense of personal privacy. Now, I've read to you the key bit of the Fourth Amendment. I mean, you might say, well, what word is missing from that amendment? Well, the word privacy, right? It's not there. So Katz kind of represents a breakpoint in Fourth Amendment jurisprudence away from historical origins in prescribing government agents from intruding in specific places or manhandling people to this more amorphous concept of privacy. Katz is basically the U.S. Supreme Court saying we're going to interpret the Fourth Amendment broadly, generously, on terms that are not reflected in the text. So in other words, we can use the Fourth Amendment not just when you do things in a person's house or go through his papers, but in general, whenever we think that, your investigative techniques invade privacy. Now, what would have happened if the dissent here, Justice Black's dissent, had carried the day? Well, there would just not have been any Fourth Amendment protection that would have extended to Katz. So why is Katz entitled to the Fourth Amendment and its protection, according to the majority? Because he expects, and he's entitled to expect privacy in the phone booth. Now, you may ask, why is he entitled to expect privacy in the phone booth? The majority in the U.S. case of Katz doesn't give any answer. It's just asserted. Now, you might say it seems obvious enough in this case, right? Phone booths have doors on them, for those who recall what phone booths look like, because we don't have them anymore. So it's not terribly controversial, socially, that people should be able to rely on a sense of privacy in them. But what I want to suggest is this inability to articulate a reason as to why people are entitled to privacy in certain contexts, that's going to become much more problematic when we get to cases about, for example, GPS data or cell phone metadata. So novel technologies where social consensus is much harder to find. So keep that in mind for a bit later in the conversation. So that might be actually a good point to turn to Canadian law. Let's call it the basic framework of Section 8 of the Charter. So the two key cases here, and we're going to focus on one today, but I'm also going to mention something about the other. The first one is Hunter and Southam. So 1984 case, sort of the seminal case framing the ambit of Section 8, and another case called R, so, the Queen at the time, v. Collins, which is a 1987 case. So these two cases together set the basic parameters for the protection that Section 8 affords us. So these two cases have to be read as a pair. Hunter and Southam is an early kind of landmark decision by the Supreme Court of Canada that sets the basic principles for Section 8 for searches with a warrant. And Collins provides the basic framework for searches without a warrant. Let's talk about Hunter and Southam. Hunter and Southam is a case that involved an investigation into a newspaper in Edmonton, which was run by a business named Southam Incorporated. Now, the people conducting the investigation in that case were not the police, but rather there were some government inspectors who were affiliated with what was known at the time as the Combines Investigation Branch, which was an agency that normally investigate unfair business practices. So they proceeded to a search of Southam Inc.'s premises and files in accordance with what was then Section 10, subsection 1 and 10, subsection 3 of the then Combines Investigation Act, which basically allowed them to conduct sweeping searches upon production of a certificate from a member of what was then known as the Restrictive Trade Practices Commission, basically authorizing such searches. So at issue in the case is the constitutionality of this legislative search scheme under Section 8 of the Charter. So what was the government's position in Hunter and Southam? Well, the government basically argued that the search power in question under the Combines Investigation Act could be exercised consistently with Section 8 of the Charter. So what did that amount to? Basically, it's a kind of trust us position. The court should basically give general deference to the government. So there's no need for oversight of this kind of search, most centrally judicial oversight, like the need to obtain a warrant, because trust us here, we'll make sure that the search is conducted properly. There's no unreasonable search and seizure here because, trust us, we at the Combines Investigation Branch and at the Restricted Trade Practices Commission will make sure that it doesn't happen. So basically, had the Supreme Court accepted this argument, I think Section 8 would basically have been hollowed out or eviscerated of any kind of meaningful content. So the first thing the court says in Hunter and Southam is this: what's the purpose of Section 8? And the answer that the court gives is it's about protecting people's privacy. And here the Supreme Court is actually explicitly drawing on the case that I mentioned to you, Katz, in favor again of a broader kind of principled reading of Section 8 in terms of protecting people's privacy. But again, why privacy, right? Why not say, dignity or liberty or, public confidence in the administration of justice? Remember the wording of Section 8. What word doesn't figure in Section 8? Can you tell me, Hugo?
Again, privacy is not in the article.
So why interpret Section 8 in terms of privacy? Section 8 is going to be held to apply only when the state intrudes upon, just like in the U.S., people's reasonable expectations of privacy. Insofar as the court holds that somebody did not have a reasonable expectation of privacy into something, then there is simply no applicability of Section 8. And so we have come to equate what a search and seizures are with this idea that the state needs to intrude upon a reasonable expectation of privacy. A search is basically that, the state intruding upon a reasonable expectation of privacy. And you might say, if the courts have derogated so much from the text of Section 8, how do we justify this? The influence of the U.S. Supreme Court's interpretation of the Fourth Amendment in terms of privacy. And you might say, well, instead of coming up with its own analysis, our Supreme Court just looks out and says, look, similar provision, similar problem, let's just import the test. But that's not accounting for the fact that the U.S. Supreme Court itself didn't really defend its adoption of privacy as the value to be championed here by the protection against unreasonable search and seizure. Justice Dixon, who is writing for the court in Southam, tries to give other reason. He says, look, there is nothing in the text of Section 8 limiting its application to property, like the Fourth Amendment. But what's the obvious rejoinder to this? Well, there's also nothing in the text saying that it's about privacy either. It's not clear in the judgment that there's anything more than, why do we pick privacy? Because it seems right. There's no developed argument on what I think is an absolutely critical point. So the choice, really seems to rest on nothing more, from my perspective, than an intuitive sense of appropriateness on the part of judges. Here again, I think there's a clear parallel to Katz. Now, this is, I say, very important because it's become natural for us now to think of Fourth Amendment or Section 8 search and seizure law in general as being about privacy. But what I want to suggest is that at its foundations, it's just not clear why privacy should be the relevant concept here. I'm not saying it shouldn't be, but you might want more by way of argument here. If it's going to be the foundational concept or value on which the whole, constitutional edifice is built. Privacy, that's a very ambiguous concept. might lend itself to many interpretations. Privacy is also thought of as the home, right? The site of domesticity. So there's probably a way to distinguish different senses of privacy. But my point is, privacy is a really loaded concept. Now, what I'll say here is that Justice Dixon in Hunter and Southam doesn't say that it's all about privacy. He says there might be other value. There might be something beyond privacy that Section 8 protects. But the next case after Hunter and Southam cites Hunter and Southam for saying Section 8 is only about privacy. The jurisprudence henceforth only focuses on privacy. So Justice Dixon says Section 8, that's actually constitutional stuff. That's not subject to limitation by ordinary legislation. So he emphasizes, and that's an early charter case, that's one of the cases where the court says, well, we should interpret the charter in a broad, purposive manner, right? But here's a counter-argument. Arguably, the fact that Section 8 is constitutionally entrenched, can't easily be modified, well, means that the Supreme Court should have preferred a narrower reading. So precisely because Section 8 is hard to change, because it's part of the Constitution, and Justice Dixon in the judgment has just reminded us that a Constitution needs to be interpreted in a way that ensures its continuing viability under varying social conditions, that it's a living tree of sorts. Well, it should be interpreted narrowly so as to allow it to grow in light of new problems, in light of new factual scenarios, as opposed to a kind of a sudden growth explosion, boom, it's all about privacy, that may then be harder to tailor to soundly address new, unforeseen issues with searches and seizures, which may arise, for example, in relation to new technology. What would a narrower judgment of Hunter Southam have looked like? It might have said that the text of Section 8 is pretty amorphous. It could point to the sweeping and general powers and conflict of interest issues in the Combined Investigation Act, the way it's framed, to say, look, this search power is quite simply unreasonable, right? Remember the wording of Section 8, unreasonable search and seizure. That is, it's not supported by good reasons in that context. So let's just come back to Hunter and Southam and the facts. Let's just think about the terms of the certificate that allowed the state agents to search and seize information. It was issued by the head of the agency in charge of the investigation. It says that investigators can look for, and I quote here, any book, paper, record, or other document. That's pretty damn sweeping. Which books, papers, records, or documents? The Act says those relevant to the inquiry. That's entirely unspecific. And then the certificate also looks to be specific to one address, but then kind of spoils that limitation by saying, and elsewhere in Canada. So it's actually an extraordinarily sweeping authorization. So in terms of the holding of the case, the Supreme Court says, no, this was not a reasonable search. Why? Well, because the court says the government didn't adequately balance the interest in effective law enforcement against the interest in privacy. So where does that balance lie for the court? The court actually relies or draws inspiration from Section 487 of the Criminal Code of Canada, which basically lays out the basic procedure for getting a warrant for searches in a building, receptacle, or place. And the Supreme Court, Justice Dixon says, that's where the balance lies. So what I would like to do now is to think a bit more deeply about why the court says this. So here's the first big motivation for the court's holding in Hunter and Southam, is that we have to protect against the police, or more generally the state, engaging in so-called fishing expedition. So while the government can search you, or can search a place, a premise, if they have good reason to believe that they'll find evidence of a crime, they shouldn't be able to search you just to see if, maybe you happen to be hiding something in your pockets. So the court really insists you need a warrant that is going to be issued beforehand, before searching. And it has to be specific. It has to explain what the state is going to be looking for, precisely enough to prevent fishing expeditions. And also, it needs to address why they think they'll find it. So that's kind of the clear default rule that is set in Hunter and Southam. All searches that are not backed by a warrant issued before the fact are presumptively unreasonable. So the message is this: you think so-and-so is hiding evidence of a crime? Well, great. Tell it to a justice of the peace and get a warrant. It's kind of a way of checking police discretion to interfere with us, to interfere with citizens. So that's the first big motivation. The second big motivation for the court's holding is that I think this requirement of a warrant, that's not going to be worth very much if the police can issue their own warrants. Well, yeah, because you might think, right, the people doing the searching, well, they're likely to be biased in favor of allowing themselves to search. And they're not likely to give enough weight to the interests of those who are going to be searched. So the court says in Hunter and Southam, the person giving the warrant has to be separate from the government agency seeking the warrant. They have to be at arm's length, and specifically not someone engaged in the investigation itself. So in practice, that means it needs to be a judicial officer. So either a judge or someone who's acting in the capacity of a judge, a justice of the peace. So that person has to listen to the government's reasons for wanting a warrant and decide impartially whether that explanation makes it reasonable to authorize the search. And then finally, the court says, look, when this neutral third party makes his or her decision about whether to grant the warrant, she or he should ask not just, is it possible that there is evidence of a crime, but rather, is there good evidence that makes it probable that there is evidence of a crime? Because, after all, even if you have prior authorization, and even if you have it by a neutral third party, if the neutral third party is just asking whether it's possible for the state or the police to find drugs or a gun or whatever, well, that also doesn't give enough weight to people's privacy. After all, it's almost always possible, right? Even if it's not very likely.
Slipping towards social profiling or racial profiling could lead to a absolute landslide of intrusion of privacy.
Yeah. So the court says, the police have to present evidence that supports their claim that they'll find what they're looking for. And this evidence has to make it reasonably probable, not certain, but at least probable that they are right. The point, I think, is that there always needs to be an evidentiary threshold. The state needs to be able to point to facts, not just a hunch, right? Not just an expression of what they feel, of what their experience tells them. They need to be able to point to facts that makes them think that they'll find, evidence of a crime or something that they're looking for. So Hunter and Southam tells us, presumptively, if you're carrying out a search, if you're going to intrude upon somebody's reasonable expectation of privacy to gather information, you need a warrant. And this warrant needs to respect what we've just said. It needs to be issued before the search. It needs to be issued by a neutral third party acting judicially. And the state needs to demonstrate up to a certain evidentiary threshold that it has good reason for thinking it's going to find the information. Dixon tells us we want to protect people's privacy here in the sense that we want to prevent privacy from being unjustly invaded in the first place. So that's what Hunter and Southam in a nutshell tells us.
So if we want to challenge a search or a seizure as being unreasonable against the Canadian Charter.
So what you need is a reasonable expectation of privacy to be intruded upon for the protection to extend to someone. Once you've decided this, once you've established this, then the next question to be asked is, was there a warrant? If there was a warrant, the question is, well, did this warrant meet the requirements of Hunter and Southam? Now, if there is no warrant, what happens then? And that's where the Collins case that I talked to you about comes in. The important point to take from Collins is that some searches that are not authorized by warrant, even though that's the presumptive requirement of Section 8, will still be reasonable if, and the court lays out 3 criteria. If that search is authorized by law, if the law itself is reasonable, and third, if the manner in which the search was carried out is reasonable. So the first requirement is that a search be authorized by law. I think that's quite clear. Either a warrant, that's a legal authorization, or some other law which says this search and or seizure is authorized. Now, the second requirement is that the law itself needs to be reasonable. And that's where, privacy rears its head again. And here the court says, when is a law going to be reasonable? We've been told that a warrant that meets the characteristics laid out in Hunter and Southam is reasonable because that is where the balance between effective law enforcement and privacy is achieved. The same kind of analysis will go to evaluate any other form of legal authorization. Is the right balance between effective law enforcement and the protection of privacy achieved by this law? Right? So that's the framework of thinking that we have to engage in when evaluating a law. And then there's always this third prong, which also applies to search with warrants, which is, was the search carried out in a reasonable way? Did the state use too much force? Did they carry out the search at night when they could have carried out during the day? So the court, post Hunter and Southam and Collins, has had certain things to say about when a reasonable expectation of privacy arises and how weighty it is. That is not to say that it's ever given us, again, a justification for why privacy is the value that's at issue here. But once we accept, let's just assume this, that privacy is a governing value that needs to be weighed against the importance of effective law enforcement, well, then we can start thinking about when is there privacy and why does it matter? So the Supreme Court has told us in a number of cases, including the Tesling decision.
That was about infrared cameras.
Yeah. So before we talk about the facts of the case, just pinpointing that actual part of the ratio here, the court says privacy is a protean concept in the sense of, that it has a kind of varied nature. It has an ability to assume different forms. And the court says the difficult issue is where reasonableness lines should be drawn. And the court says the inquiry here should be normative. So the question is about what expectations of privacy people are entitled to have. Which expectations of privacy should be protected? So the court basically in its jurisprudence has outlined a number of factors that should be looked at in answering this question. So what was the place of the search? Who had control over the subject matter of the search? The private nature of the subject matter, whether the subject of matter was in public view, whether it was abandoned, whether it was already in the hands of third parties, whether the search method was intrusive in relation to the privacy interest at stake, whether the search method was itself unreasonable, whether the search exposed core biographical information, a long list of factors. And then the court has said none of these factors in and of itself is determinative. And in fact, the list that I've just given you is not exhaustive. So the court has said the existence of a reasonable expectation of privacy and its weight is a contextual, fact-based inquiry to be assessed based on the totality of circumstances. So the analysis in the end leaves much to judicial discretion.
I think our listeners will understand that there's a lot of common sense behind all this.
Well, let's ask ourselves whether you agree with so-called, quote-unquote, I'll say common sense sort of implications of what I've just talked about. Mm-hmm. So let's talk about a number of decisions, and you tell me whether you think they meet your common sense intuition. So here's one case, Duarte. Duarte was a decision that dealt with the practice of so-called consent intercepts. So what is that? So it's a practice according to which you have a police informant who wears a wire or some device of that kind to record their conversation with a suspect who is unaware of this fact. So that's referred to in the judgment as participant surveillance. So in that case, the majority of the Supreme Court held that the fact that a person tells purportedly private information to someone else, and this someone else turns out to be, let's say, a false friend who can't be trusted with such information, and then turns it over to the police, that does not attract the protection of Section 8. Unless the court says this information is recorded by means of a permanent electronic recording. Justice Laforêt, who's writing for the court here, says, the charter is not meant to protect us against a poor choice of friends. If our friend turns out to be an informer and we're convicted on the strength of his testimony, that may be unfortunate for us. Now, here's my surprise, right? Think about the historical pedigree associated with oppressive regimes' widespread use of informants. Think, for example, of life, in the Soviet Union or in East Germany, right, during the Cold War. So you never knew whether, one of your coworkers, one of your friends, quote unquote, or one of your family members, were secretly speaking to the authorities about your behavior or your statements. So this kind of state practice, you might think, breeds social distrust, breeds suspicion, right? But Duarte doesn't protect us against such state practice, insofar as no formal recording is involved, because Justice Laforest says, well, there is no reasonable expectation of privacy in it. If I reveal my secrets to you, you can also reveal to somebody else. But then, no protection of Section 8. For me, that there's a real tension here.
A secret is not a secret once it's been told to somebody else. My reflex would be, if you talk to somebody and that person remembers the conversation and tells it to the authority, that should be all right.
So that's what the Supreme Court thought. What I'm suggesting to you is that allows for a society in which live informants without recording are used endemically, like in the Soviet Union, like in North Korea, like in East Germany. There's no bar to this, right? There's no assessment of reasonability because the thought is there is no reasonable expectation of privacy. Here's another case for you, Hugo. Testling, 2004 case. Yet another emblematic Section 8 decision. You mentioned earlier what it's about, right? So the Supreme Court held in Testling that police use of infrared camera that's affixed to an airplane to kind of overfly a home and detect the presence in it of high intensity lamps for hydroponic marijuana cultivation did not invade an occupant's reasonable expectation of privacy. So the reasoning of the court here, and Justice Binney is writing for the court, is heat emanations from your house, they reveal something about what's going on in your house, that you're doing something that generates heat, but doesn't allow for very specific inferences about what you're doing in your house. Now, a very similar case in the U.S., a case of Kelo, led to a different outcome, where the U.S. Supreme Court says, what's at stake here is the house. It's information about the house. The house is sacrosanct, going back to the common law, right? But here's how I would like to press this. Imagine the state puts infrared cameras on drones, on millions of drones, overflying our cities to detect on a constant basis the kind of heat emissions coming from houses. Do you think that's the kind of reasonable state action that we should just close our eyes to and accept, in a free and democratic society? Section 8 does not guard against the state engaging in this practice.
A camera is a camera is a camera, whether it captures visible light, infrared, or as soon as you start recording somebody, especially in the privacy of his own home, I tend to agree with you and disagree with the Supreme Court for Testling.
Let's again push your intuitions. Let's think of another case, a more recent case, a case of Patrick. So Patrick is a case where, someone had disposed of drug paraphernalia in their garbage bin, which was just located inside their property, but on the limit of the property lot.
Yeah, Patrick is 2009.
Correct. And so the question there is, do you have a reasonable expectation of privacy in your garbage, right? The court in Patrick says, no reasonable expectation of privacy in waste. The court says, obviously your garbage can reveal a ton of things about you, but no reasonable expectation of privacy in that because you've abandoned it. So the question is, have I really abandoned it before the garbage collectors have come? I could always go back and, retrieve the stuff from my garbage can. In Patrick, it was also the case that somebody would need to cross into the property line, so commit the trespass in order to access the property. And the court says, no, that's no problem, because the person had, quote unquote, abandoned it.
Stick with Patrick. I tend to kind of agree with the narrow definition and go back to the Fourth Amendment, the right of people to be secured in their persons, houses, papers, and effects. I think that it's still mine.
In the U.S., you have judgments who insist on this on very similar grounds. The case is called Jardines. But again, because we've decided to limit the ambit of Section 8 to reasonable expectations of privacy, suddenly in Canada, we say no protection. McGregor, 2023, very recently. So our Supreme Court has recognized that the information that we have on our computers is colossal. If you get to somebody's computer or somebody's phone, you could discover so much about their lives. The court says if the police or the state have a legal authorization to search for a specific kind of file on your computer, if in the process of carrying out this tailored search, they stumble upon some file, some information that is evidence of a crime that is not related to the investigation, that's fair game because that information is quote unquote in plain view. The court says that's okay, right? Your interest in privacy on what is contained in your computer is not sufficient, is not strong enough to make it the case that the police should just turn its eyes away. Now, think about how computer searches are carried out. It's kind of very difficult not to stumble upon other things when you're carrying a search. You're likely to encounter other things, right? But again, privacy doesn't stand in the way, right? So my suggestion to you, Hugo, here is that this reasonable expectation of privacy framework has led to counterintuitive outcomes in a number of cases where you think, well, Section 8 should at least have something to say, should at least kick in as a protection which allows us to assess the reasonableness of the state action, as opposed to just saying, because there's no reasonable expectation of privacy, we're just going to turn a blind eye to what the police did. They just can't review legally or judicially what they did. Where does that leave us? Right? Well, I see the time going, but I still want to speak about what I think are really important, more recent developments in Section 8 jurisprudence.
Do you hear anybody stopping you?
Well, there we go. You can tell, I think you go down very enthusiastic about this stuff.
Because I want to talk about Maraca. I want to talk about Bykovets. I want to talk about a recent decision in the Superior Court of Manitoba. Justice Victoria Cornick talked about cellular. Is it a thing or a place? And obviously, where it's going to lead us.
I think that the reasonable expectation of privacy framework is on the cusp of being revisited if it has not already been revisited. So in a number of recent cases that are related to digital communications and the internet, I think tables have turned quite drastically. In those cases, the court has seemed pretty eager to extend the purview of Section 8 to matters in respect of which, given its prior approach, one may not have expected it to recognize a reasonable expectation of privacy. In Maraca, which is 2017, the accused actually sent incriminating text messages to an accomplice. Now, during a search of the accomplice's house, the police seized and searched the accomplice's phone, found Maraca's text messages on it, and then sought to introduce them as evidence against him. Chief Justice McLaughlin held that even if Maraca had already sent the text messages to his accomplice, and they were stored on the accomplice's phone, even if Maraca had no proprietary interest in the accomplice's phone, nor any real control over how the accomplice used his phone and to whom he could forward the messages, and even if the place of the search was not determinative, Maraca still had a reasonable expectation of privacy in the sent messages. Now, why? How do you explain this holding? So according to Justice McLaughlin, the focus of the inquiry here should be on the potential of a given electronic conversation to reveal personal or biographical information. And then building on that premise, she says, it's actually difficult to think of a type of conversation or communication that is capable of promising more privacy than text messaging. Now, fast forward from Maraca to what I think is the key case where tables might actually have turned. The 2024 decision of the court in a case called Bykovets. At issue in Bykovets was whether people have a reasonable expectation of privacy in the external IPs or Internet Protocol addresses that are associated with their activities on the Internet. In a prior decision called Spencer, the court had already held that an Internet user has a reasonable expectation of privacy in the subscriber or identifying information that is associated with his or her use of a given IP address. So the issue in Bykovets was with the IP addresses themselves, right, devoid of identifying information. And the majority of the Supreme Court, it's a deeply divided court, it's the 5-4 decision here, held that internet users also have a reasonable expectation of privacy in such bare addresses. Now, Justice Cote, who's writing a dissent here, says, look, an IP address actually reveals nothing. It doesn't convey any information about who you are, about what you do. It's just a series of numbers. But Justice Karakatsanis in the majority says that's not how we should think about the issue, right? We should think about the issue as follows. She says we should try to define the subject matter of a search in terms of the potential of the information to reveal personal or biographical information. So whenever you have something that potentially could reveal, let's say, private information, we should hold that there's a reasonable expectation of privacy in that. And she says an IP address is the first digital breadcrumb, the key to so much personal information scattered around the internet.
The Supreme Court concluded that what the police were really after in seeking subscriber information on IP addresses was the identification of an individual linked to specific online activities, so tend to reveal. So they're looking for pieces of the puzzle in order to reveal maybe a bigger picture.
But notice, Justice Cote in dissent says, yes, right, if it were aggregated, that might be an issue, but in this case, it wasn't. The police was just after the IP address, period, and did not aggregate it with anything else. Now, in the US, in more recent technological kind of search and seizure cases, there's a new kind of theory of privacy that has arisen, which is referred to as the mosaic theory of privacy. This mosaic theory requires courts to apply the Fourth Amendment to government conduct as a kind of collective whole, rather than in isolated steps. So instead of asking if a particular act is a search, the mosaic theory asks whether a series of acts that are not searches in isolation amount to a search when they're considered as a group, because their collection and then subsequent analysis kind of creates a revealing mosaic. You might say, well, that's what's going on in Bykovets, but not quite, because there is no aggregation in Bykovets. So what's the result of Bykovets? I think it's the following. If you have a reasonable expectation of privacy that exists in a piece of information because of what it may reveal about someone's identity, about someone's activities, if it's aggregated with other pieces of information. But even in situations when it's not aggregated with them, in fact, where that's what happened in Bykovets, then the list of pieces of information to which a reasonable expectation of privacy attaches is likely to be very long indeed. So potentially, as Justice Cote says in her dissent, it could include almost any potentially identifying evidence, right? And so that leads us to ask, what's left of the reasonable expectation of privacy threshold posed by Bykovets? My suggestion to you is that maybe not much. So if anything that could lead you, if aggregated with something else, to identifying information or information that might be revealing of your association with crime in any way, even if it's not aggregated, if that entails a reasonable expectation of privacy, then you end up with a reasonable expectation of privacy in a really, really long list of things that intuitively we might not think carries a reasonable expectation of privacy. Do you have a reasonable expectation of privacy in your car license plate? Do you have a reasonable expectation of privacy in your home address? Do you have a reasonable expectation of privacy in a piece of clothing that may be connected to your identity? What about with your phone number? If my interpretation of Bykovets is correct, then the need for a real reasonable expectation of privacy, at least based on the analysis that we had gotten used to with how the Supreme Court interpreted that concept, is kind of vanishing, right? So you might end up in a situation where, and I think that's personally, if you ask me as a law professor who's thought about this for a long time, where we should be going, well, maybe where we're heading is a situation in which whenever the state non-accidentally looks for or gathers information about us, any kind of information, even information in the public domain, it should do so reasonably, right? Section 8 should apply to it, and we should be in a position where courts can opine on whether it was reasonable or not. So we live in a society where there's so much information about us out there that if you were to sort of aggregate it, even if it's public information, it could give you a lot of information, say, about me, about what my habits are, about what my likes are, about, what I do, what I want, etc. And with this information, you could potentially interfere with my life in ways that could shape it in ways that I'm not even realizing. We hear about all sorts of events or, scandals around the world that have to do with big tech companies having aggregated so much information about people that are even able to sway the result of elections, for example. A lot of that information is public. Do we want the courts to be able to evaluate what the states do? One objections to this might be, well, if Section 8 applies to every non-accidental collection of information by the state, then the amount of warrants that the state is going to have to obtain is going to be so colossal that it's going to cripple law enforcement ability. That's Justice Côté's objection in Bykovets. But remember, Collins, you don't need a warrant. Having a warrant is just the presumptive kind of requirement of a reasonable search and seizure under Section 8. There could also be other kinds of legal authorization. And in fact, the states already, if you look at the criminal code, there's a bunch of ways in which the state can acquire information about us without a warrant, right? If there is an exigent circumstance and the state has reasonable grounds to believe that it can, obtain information that, say, might disappear, the criminal code says you don't need a warrant. Or, if you're legally already in position to carry out a search and then you turn around and something is in plain view, right? Something you see there that's related to another crime, you can seize that too. You don't need a warrant for this. So my suggestion is that given that information is power more than ever before, given how much information is out there, given the digital reality of our lives, we're all carrying our phones at all times, we're tracked and our activities are tracked on a constant basis, it might be a good idea to actually force the state to turn its mind to when it can collect that information and set boundaries to it that courts deem to be reasonable as per the wording of Section 8.
The way I'm reading Bykovets, I think the court is seeing that the world is becoming more and more connected. Everything is going to be connected. Forget about the license plate on your car. Your car is going to be connected. So whether there's a license plate or not, it makes no difference. I think that they're saying that because everything is going to be IP linked, there's going to be an IP on every single thing. They're saying that right now we should tone down anything that has to be with the online lives of people because a user's internet activity ultimately leads to that person's identity. That's the way I'm reading Bykovets. I don't think that they've opened a new interpretation of Section 8. I think they're saying, let's be careful right now because everyone is going to be 100% online and everyone will be identifiable very easily.
Is really privacy doing all the work that we want Section 8 to do? My thinking is there are other things that are important, right? So holding information about people, accumulating information about people, even information that is public, gives power to the holder of the information. And we need to be able to hold that power in check. The ability of tracking somebody who's walking around in the street in public, knowing where people are going at any time of the day, that gives power to the person who knows that. Nobody likes to be stalked because they know that the stalker has power. Now, you might say, well, that then, walking on the street in public is private. That's kind of what the Supreme Court did in a case called Spencer, which we mentioned earlier. It said, well, one dimension of privacy is anonymity. Now, I want to quibble with this because imagine that, I step on a stage, wearing a very good disguise. It's so good that you can't know it's me. And I make, really controversial political remarks about, the state in which I live and my community, etc. And then I take off. It'd be a bit weird to say that what I said was private, right? I said it on the stage, and yet it was anonymous. So I'm not sure that anonymity is important because under the cover of anonymity, sometimes it gives us the courage to say things that we wouldn't say otherwise. Bad things, but also very important things in the political context where, political regimes might become, more and more authoritarians and we need to, fight against it. So my sense is trying to to fit everything under the heading of privacy kind of clouds, other values that are important and worthy of protection when it comes to the gathering of information. And here I think back to Hunter and Southam. So we may want to ask ourselves, was Hunter and Southam wrongly decided? My suggestion to you is that no, it wasn't. But it was not if you read it properly. It says privacy is a very important value that Section 8 should protect. But other values beyond privacy might also be worthy of protection under Section 8. And that courts, including our Supreme Court, seem to have forgotten. Bykovets makes me think that at the back of their mind, they're not realizing that collecting information, including public information, might be problematic and the state might need to be held in check in its ability to do so. My sense is we're at the cusp of a possible resolution. It's possible that courts are just going to double down on the hold reasonable expectation privacy inquiry. There are some judgments across the country that read Bykovets this way. But my way of looking at this is, why not try to run with the insight that was at the core of Hunter and Southam and also exists in U.S. jurisprudence, that other values might also be important. Liberty matters, dignity matters, anonymity matters, property matters, public confidence in the administration of justice matter, and those are not all matters of privacy. You can try to all reframe them as matters of privacy, but ultimately I think that confuses what's at stake. It'd be much better for us to have a richer dialogue around these issues than just double down on a certain interpretation of Hunter and Southam, which might not be warranted.
So tell me, were we wrong with the Shaping Canada 150 years of landmark decisions, deciding that Hunter v. Southam was a landmark decision?
No, because I think the collection of information and the power that it gives the state over us, it's more than just the state, right? Big corporations also collect tons of information about us, but we're talking about the Constitution and its applicability to the state now, is at the nerve, at the core of the information age, and at the core of the dangers that we face, citizens of Canada and citizens of the world. The ability that we have to live freely, if that capacity of collecting information at will is not curtailed, is on the cusp of maybe being curtailed in ways that we haven't envisaged, right? We're talking about the rise of authoritarianism around the world. Well, we certainly don't want this to happen at home. And I think Section 8 and the kind of protections that it affords and the further protections that I think it should afford is at the core of what ultimately can allow us to remain as a kind of free and democratic society, which is what the Charter is all about. It's not the only thing, right? As a democracy, we also need to think about what kind of legislative protection we want to extend to ourselves beyond just curtailing the powers of the state, but the state remains a very powerful actor. I, qua citizen, want to make sure that whenever the state seeks to know what I'm doing, it's justified in doing so, that it has good reasons to do so, and the structures need to be in place to control that.
Professor Tanguay-Renaud, thank you so much for sharing your insight. Thank you for taking all that time with us. I think it's very important to tell our listeners, go read Southam. Very short decision, 13 pages. It's a lot of reference to cats, as you said. And I believe that your article, Rethinking the Applicability of Section 8 of the Canadian Charter for the Information Age and Beyond, which will be linked in the episode notes, I think it's something that should be shared and thought in not only in the school system, but in the general public. Thank you again, Professor François Tanguay-Renaud.
Thank you so much for having me, Hugo. The pleasure is all mine.
Thank you for joining us for this episode of Shaping Canada, 150 Years of Landmark Decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Cazirard, Suzanne Côté, Andromache Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin, and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Backen, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.